Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-3081, United States of America versus Amistad Veney, appellant. Ms. Wright for the appellant, Mr. Hansford for the appellate.
Morning.
Morning. May it please the court. Lisa Wright, representing Mr. Amistad Veney. I'd like to reserve 2 minutes for rebuttal. The district court here committed legal error in concluding that Mr. Veney's continuation of his forward motion was per se inconsistent with submission to Officer Torres' show of authority.
Is that microphone on?
Is it on? Microphone? There's a green light.
Yeah.
Can you hear me?
Okay. Must be me.
No, I was having trouble too.
Oh.
Me.
Maybe pull it a little closer to you.
Is that better?
I think
Yes.
so.
Yes.
Okay. Because the district court mistakenly concluded that Mr. Veney could not submit while he continued to walk, the district court did not address at all or even mention Mr. Veney's argument that he submitted by immediately turning around as Torres had requested. Here we have the body-worn camera video from which the court can see that Mr. Veney did indeed submit. Because the facts are fully available to this court via the VWC, the court can and should conclude that there was a submission and suppress the evidence that was the fruit thereof. In the alternative, if this court agrees that the district court committed legal error in finding that Mr. Veney's forward motion was determinative, but was inclined to have the district court address the significance of Mr. Veney's turn in the first instance, a remand for that purpose would also be appropriate.
Can you clarify what your test is for submission? Does Mr. Veney have to both stop and turn around in order for there to be submission?
No, because
one would be enough.
Well, the request was to, we would say the request was to turn around. It was a rejection of Mr. Veney's rejection of the request to turn around.
And you think that he fully turned around and faced the officer?
I think that he gave the officer the view that the officer was requesting because he wanted to see his front, and he could see his front because of the way the angle was. He was able to see. In fact, I mean, the side view was really the
So I've watched that body cam, at 15 seconds over and over. And I guess, what if I do not disagree with any of the district court's factual determinations? Is it possible for you to still win this appeal?
I believe so, because the court didn't even address the turn. That was our argument below, that he had to submit it by turning, and the district court does not even mention that argument in the opinion because the court thought it did not matter since he was moving. And we understand that the video is very fast. Everything happens in 2 seconds, and in fact, he really submits in the first second, because if you look, when he says no, the counter is at 33. And then he takes a step, he takes a left step and turns his head, that's on page 19, I believe, takes the right step and turns his body, and that is page 20. And then on 21 is when he hesitates. And the counter there is still 34. So we understand it's fast, but there is a way, and I don't know if others are more tech savvy than I am, but you can put playback into super slow mode, and that does help. But we believe our screenshots do show the submission.
You think he stopped walking away?
I think he continued to move, but at worst for us, what the district court said was that he would not feel free to leave until he showed that he did not have a gun. So that's not saying there was no halt, there was no hold on or stop order. So what we would say is he couldn't leave without turning around, and he did do that. He did turn around, and he wasn't, walking away because he was already walking, and the government acknowledges that. He was within his rights to have walked away. That's when he walked away, was initially. After that, he simply continuing to do what he's doing, only he's turning around to show his front. And I think it's really on all fours with the Gibson case, where the command was, let me see your waistband. In that case, police had pulled up beside someone who was walking, and that person continued walking while their shirt was lifted. And the district court found that that was a submission. And here we would say it's even a stronger case, because in Gibson, they were maintaining the same distance from each other. And here, Mr. Veney actually hesitates before taking that third step, such that they're getting closer, and he's allowing Torres to draw closer to him. He covered like a half a tree box distance, while Torres covered the whole tree box. I mean, he was letting him come to him in a way that Gibson wasn't.
So the dialogue that precedes all of this is, big man, you got nothing on you, man. And Veney responds, I don't got S on me. And then he says, you mind turning around for me? And he says, I'm not, man, nah, I'm going to walk off. That's what the district court finds.
Yes.
And then Torres presses the matter by saying, no, I just want to make sure you got no guns. The district court makes a finding at the bottom of page 84, A34, carrying over to the next page, that as far as the seizure goes, the district court makes a finding that Veney has satisfied his burden of producing evidence showing that a reasonable person in his shoes would not have felt free to leave until he proved to the officer that he did not possess a gun. You don't challenge that ruling.
To the extent, yeah, to the extent that's a factual finding. I mean, I actually believe that our main argument, we believe we prevail under that interpretation of the exchange, but we actually think that it's simpler than that, and it's just he wants him to turn around, he refuses, and he says no, and that it really is just a rejection of Mr. Veney's rejection, and he's saying no, turn around. I asked you to turn around, and you declined. I'm saying no. So, but even under this interpretation of that passage, we would still.
So if the ruling is that a reasonable person would not have felt free to leave until he proved to the officer that he did not possess a gun, then the district court followed from that, then that he was seized and he was not free to leave, and because he continued walking, he did not submit. So if the ruling is correct that a reasonable person would feel that they were not free to leave, but he left, tried to leave by walking, how is that an erroneous ruling?
Well, a couple things. I mean, he isn't actually leaving Officer Torres because Officer Torres has followed him. He left Torres originally. That's one thing. But I would say that, I guess to the extent he
For
is
the
saying,
Fourth Amendment, you have to be successful in leaving. You have to get away. I mean, even if you don't successfully leave, I mean, we wouldn't have cases if the people who fled were successful in fleeing.
There's no flight. I mean, this is not a flight situation, but I understand what you're saying. But if you start walking, that is different than continuing to walk. That is our point. And I think Brendlin, the Supreme Court said, what you're doing beforehand is significant to whether there's been a submission. And here all he does is continue. And in fact, he doesn't exactly continue. He slows down, he hesitates. And I guess this
We'd have to find clear error to find that, though, right? Because the district court finds that he walked at the same pace.
I think that is probably correct, but there is clear error on the body-worn camera because you can count the steps and you can see him hesitate on page 20, I think I actually have a typo in the brief where he's hesitating most clearly is the top of page 21, not page 20. But yeah, I do think when the district court said he walked at the same pace, that's not accurate. And partly it was because, the judge really didn't care what pace it was, I think, because he just thought he was moving and he was leaving. But as far as with him saying you have to prove to the officer he didn't possess a gun, I want to be clear, we're not certainly thinking that would mean or agree that would mean that he had to, strip down or in some way literally prove he didn't have a gun. But it's, until he shows the government, the cop, what the cop is asking to see, because the cop is interested in the gun, and I think, and whether he has a gun. And I think he says, like we say in the reply, when he's basically saying, would you mind doing X for me? And Mr. Veney says, no, I'm not going to do X, I'm going to do Y. And the officer says, no, I just want to make sure, Z, make sure you don't have a gun. And so the no is really saying, give me what I want, which is to see that you don't have a gun. And the turning around satisfies that. And indeed, that's exactly what the officer had asked for originally and been refused. I mean, that is the request that, and he's already legitimately walking. There is a difference between starting to walk when you think you can't leave without showing. But this is all happening simultaneously. He's already walking, just as in Gibson. It really is. And the government doesn't dispute that Gibson is correctly decided. They try to distinguish Gibson. I'm not really clear on the distinction they're making, but they seem to be saying that somehow Mr. Gibson is keeping up with the police car, when really, just as here, the police car is keeping up, and in fact, in our case, gaining on defendants.
I mean, it's clear that Torres is walking faster than the appellant because, he's several feet away from the appellant when the appellant starts walking. So I'm not sure kind of where that gets you, where the district court finds that they are essentially parallel when Torres observes what he believes to be an imprint of a weapon. And the district court makes that finding, right?
Well, I believe we do dispute the court's summary of the body-worn camera footage, because the court skips over entirely the turn, which was our whole argument below. He summarizes it as Officer Torres, while walking a few feet behind Veney, quote, no, I just want to make sure you got no guns, and then skips and says the next thing, Veney, as he walked at the same pace down the street with Officer Torres walking parallel beside him, don't got S on me, what are you talking about? This is a belt. We do not accept that factual description of the body-worn camera, and I understand it's quick, but that's simply not what happened. And I just think it's telling that the district court doesn't even take on the turn. So, if this court, were to remand to the district court to take it on, that would be one thing, but I don't see how we can lose on the facts here when the district court didn't even really address the fact that we're focusing on and just kind of skipped over it. Because you can't go from being a few feet behind to walking at the same pace parallel. In fact, something happened, which was that he caught up with him. And part of the reason he caught up was that hesitation on that third step. They're keeping pace with each other.
Are you saying that the district court found that the two men, Officer Torres and Veney, were walking at the same pace?
No, I guess, no. He's saying that Veney continued to walk at the same pace with Officer Torres walking parallel beside him. But again, the court gets him there from walking a few feet behind and doesn't address how it was. It was because Mr. Veney turned and hesitated. They were keeping the same pace initially, although Torres' steps were bigger, they were taking the same number of steps. When he said, no, head turn. No, I got that back. No, head turn, body turn. At that point is when Mr. Veney hesitates and Torres takes a step, and then together they take the opposite step. And by that time, but truly in that first second is when the turning and the hesitation took place. And the court just didn't consider that below because it didn't think it mattered. Because
Your argument revolves around the proposition that he was stopped earlier than the district court found. Is that?
that he was stopped.
But why wouldn't it still be justified as a Terry stop? Because it's a high crime area known for firearms. He was walking away, making furtive gestures, trying to conceal something in his waistband. And why isn't that enough to stop him anyway? And then, once having stopped him and noticing the bulge, which turned out to be a firearm.
Well, the government has.
You didn't dispute that part of the district court's findings, did you?
Well, we dispute the district court's characterization of Torres's testimony with respect to the hand positioning.
Positioning, yeah, but what I'm not talking about that. I'm talking about the observation that he was making gestures to try to conceal something in his waistband.
Yeah, but that's not what Torres said, what we're saying. So we don't agree with.
Well, first of all, district judges don't even have to write an opinion in this kind of a case. They can just say denied, right?
The district court did not find that there was reasonable suspicion at that point. The district court said the linchpin of its reasonable suspicion finding was the seeing of the bulge.
Yeah, but we're not bound by that. I mean, this is de novo review.
Well, the government isn't asking this court to find reasonable suspicion. The government's asking for a remand for the district court to consider that because it was never considered. We would say the district court implicitly rejected that because it did not even mention that potential thing that it was holding
Well,
open.
that doesn't mean the court rejected it because he didn't mention.
Well, if he had, well.
He didn't need to mention.
That's correct.
Yeah. All right.
That's
Can I get clarity on something your client said on the body cam? Your theory today and in your brief is that we know he submitted because he turned around enough for the officer to see the bulge, right? Is that a yes? Is that a yes so far?
Sorry.
You nodded yes, but is that a yes?
Yes.
Okay, thanks.
Sorry.
But I think on the body cam video, your client says something like, "You didn't see nothing, man. I walked off." So how is that consistent with your theory?
Is Your Honor referring to when he says, no, I'm going to walk off?
No, it's later. I think the officer says, "I saw the outline, bro." This is not a direct quote.
Right.
And then Mr. Veney responds with something like, "You didn't see nothing, man. I done walked off."
Not sure exactly what point. You were saying that was in response to Torres saying what?
I saw the outline.
Saw the outline. I think that's much later. When they're arguing by that point.
Right, but that's my point, I think, is that if it's much later and Mr. Veney is saying, "You couldn't have seen the outline of the gun," right?
No,
then,
I think he's saying you can't see it. I mean, right now, as you're looking at, he's pointing at it at one point, and he's saying, "Well, what is this?" And he's like, "This is a belt." And he is disputing, what the officer is seeing.
Just help me see or explain why there's not tension between your theory that Mr. Veney turned around enough to show the officer the bulge where the gun was. Contrast it with Mr. Veney's later statement. "You, the officer, couldn't have seen anything. I was walking off."
I would want to listen to that tape again because I don't really remember the wording being like what Your Honor's saying. I thought it was, if anything, he was saying pointing at him in his waist, he's saying, "What are you talking about? This is a belt." He's acknowledging that the officer can see a bulge. He's trying to persuade him that it's not contraband. That's different than acting like he thinks that it couldn't be seen. I mean, I'm not saying Mr. Veney might have been hoping he didn't see it, but he did reveal what he asked for. And I mean, it's kind of notable that in a couple of the cases where evidence has been suppressed for compliance with a command like In both Mabry, for example, and in Brody, the compliance doesn't actually yield the fruit. The person runs off and then the fruit is revealed. Here, he actually gave him exactly what he wanted. It yielded exactly what he wanted. And I guess we would say that is a very clear submission.
All right, thank you. We'll give you a couple minutes in rebuttal.
Mm-hmm.
Mr. Hansford?
Good morning, Your Honors, and may it please the court, Eric Hansford, the United States. The defendant's claim that he submitted in this case fails for two separate and independent reasons. First is, as the district court found, the show of authority meant that the defendant was not free to leave, and yet the defendant was continually trying to walk away throughout the encounter. And the district court specifically finds that he was trying to walk away in footnote 4 of the opinion. Second, even assuming that the defendant could have complied by turning around as he was leaving, the video makes clear that he did not ever turn around. And instead, as the district court found, the officer spotted the gun from the side as he was overtaking the defendant. So for both those reasons, the defense argument does not.
Let's suppose we don't agree with the first proposition and we agree that he could have submitted by turning around, but there's no finding by the district court as to exactly whether he did turn around or whether it was sufficient to be a submission. Why shouldn't we remand instead of kind of making that factual finding ourselves in the first instance, which we don't do as a court of appeals usually?
So I think you do have a factual finding, an important factual finding from the district court on page 65 of the FSUP, which I think is 36 of the appendix, where the district court is saying the officer saw the gun from the side, and contrasting that with the post-arrest photos or the arrest photos that are taken from the front, and explaining that it makes sense that the officer would have been able to see the gun from the side even if you couldn't make it out from the front. And so I think that's perhaps not the most explicit finding, but I think that is a finding that the officer is seeing it from the side, and therefore that's inconsistent with the turning. I think that.
How is that inconsistent with the turning theory? I mean, if you see something from the side that is in the front of the other person, you either have to be in front of that person slightly or that person has to turn slightly to you for you to see their front.
Well, I think when you take it in conjunction with the body-worn camera, which shows the officer walking past the defendant, looking over to his right as he's doing so, I think the finding that it's made from the side does mean that the officer is spotting it, not as the defendant is turning, because then the finding, I think, would be that he's seeing the gun from the front.
So we have to infer that that's what the district court found, since we don't have an explicit statement to that effect.
I think you don't have a completely explicit finding on that, but I think that's the reasonable inference from the district court, from what the district court's saying. I think you can also look at the body-worn camera here and say that no district court is going to be able to find that the defendant did turn based on this body-worn camera, where there's no indication in the transcript, there's no testimony or other evidence that he did turn. There's just nothing to suggest that he did turn.
You don't think I can look at the body-worn camera and see that there's at least a slight turn?
I don't think so. I don't think there's a slight turn in the body-worn camera. I think if you, especially the full scope of all three body-worn cameras, I think from certain angles it might seem like he was starting to turn, but then I think when you're looking at Jacobs and McCaw camera, it's clear what he's doing. He's actually inflating his body. But I do think, I think the first point is the reason there's more explicit findings on the first point that the defendant was not free to leave is because that was the primary rationale for the district court's opinion. And we do think that rationale is fully supported by what the district court's saying. I guess I'm having trouble understanding the defense argument. As I understood to the court's questions, to Judge Wilkins' questions, the defense is accepting the finding that there was a show of authority that required the defendant not to leave until he proved that he didn't have a gun. And so I don't think that is, I think that show of authority finding is going to control the fact that the defendant was continually walking away.
So let's do a little demonstrative.
Sure.
Let's suppose I'm the defendant, you're the officer. I do like this. See, walking. I don't stop moving. Have I submitted?
No, not on the district court's fact finding.
You couldn't detect any bulges with a robe on anyway.
So I think you can see that for a couple of, both factually and so the factual bucket is the full context of what the conversation happened. So the officer approaches, says, "Do you have anything on you?" And it says no. The officer says, "Would you mind turning around for me?" That's not the show of authority. Defendant says, "No, I'm going to walk off." The officer then says, "No, I just need to make sure you don't got no guns on you." That's the show of authority.
And the way that he wanted him to do that was turning around.
I don't think a reasonable person would understand that merely turning around as you're walking away in that full context is going to satisfy the officer. Instead, I think what you have here is the reasonable inference is the officer, this is what the district court's finding, the officer's trying to determine if the defendant has a gun. Part of that may be turning around, but it's not for the defendant to decide on his own that all he needs to do is turn around, and then that's going to satisfy.
But that's all he was told to do, is turn around or ask.
I mean, no, I think what he's being asked to do and what the show of authority is to stop. The no, I just need to make sure you don't have no guns. That comes directly after the defendant says, "I'm going to walk off." And then he starts walking off. So the no, I think, is most easily understood as responding to that. And that's supported by the larger context.
But the defendant's no is most read easily or reasonably responding to the request that I want you to turn around for me.
That may be right, but I don't think the defendant's no is what's controlling the show of authority here. It's the officer's words in the show of authority. And I think you also see this in the case law, both in the more general sense that how this court commonly and the Supreme Court commonly defines what a show of authority is, what a seizure is a situation where the person's not free to leave. So we go through some of that case law in 21 to 22, even just the language of it's a Terry stop, it's a detention. That is indicating that you are not free to leave at that point. But then you also have the more specific cases. Maybe Brody's the cleanest example, where the officer pulls up beside the defendant, says, "Put your hands on that car." The defendant does so for a few seconds, and then the officer turns away and the defendant runs off. And what this court says is that when he puts his hands on the car and remains there for a few seconds, that's brief submission. But that when he runs away, that's no longer submission. So in other words, implicitly, what this court is saying in Brody, I think is consistent with Mabry, is that it's not just that he had to literally comply with the command by putting his hands on the car and then he's free to leave. It's that he has to put his hands on the car and remain there until the officer indicates that he's.
But an order to put your hands on the car has a different purpose than an order to turn around. The officer in Brody didn't order him to put his hands on the car just so that he could see his hands and observe his hands. It was so that he would be there in a position so that he would be seized and could be frisked, right?
We don't know exactly what
Well, why else would an officer lawfully, what other lawful basis would an officer have to tell somebody to put their hands on a car? Other than put your hands on the car because I intend to frisk you.
I mean, I think in Brody, what you have is a situation where a defendant's leaving the scene of a warrant. So it may just be that they're ultimately identifying him. It may be that they're frisking, but I would say that's the same as this case, which is that it does the officer no good if the defendant, as he's walking away, turns around, revealing a gun that would confirm the officer's suspicions, and you understand at that point that the defendant is nonetheless still free to walk away. What is understood?
It seems like you're blurring the analysis here with that statement. I mean, if Veney had turned around as soon as the officer asked him to and said, look, okay, and then started walking away, he would have complied with the officer, right? Unless and until the officer told him to stop.
So there is no show of authority at the time that he's asked to turn around, and it's a request. It's not a command to turn around. And so I mean, I think at that point, yes, he's fully free to leave because there has not been a show of authority.
Well, but once there's a show of authority, isn't there a presumption, maybe a rebuttable presumption, but a presumption that the suspect is not free to go?
Right. I mean, I think that's generally what a show of authority means. Exactly. And I think that is what this court is saying in the Mabry case and the Delaney case in defining a show of authority as a situation where the defendant's not free to leave. And I think this goes to Brendelin more generally talks about how there are public safety concerns anytime there are these sorts of interactions, and what you want to address those public safety concerns. Right, he says to this as well, put the officer unquestionably in charge of the situation, for the officer to be the one who's indicating when the seizure is terminated. And that's what a reasonable person would understand in that context. So if there is no legal basis for it, then the remedy there is to go to court and test whether or not there's reasonable articulable suspicion, as opposed to the defendant deciding on his own to kind of narrow the officer's request and turn away and walk away. That's when you run into public safety problems that are indicated in Brendan. And just lastly, on Judge Randolph's questions about reasonable articulable suspicion in this case, we do agree that given the district court's finding of kind of the furtive movements plus the high crime area could support a finding of reasonable articulable suspicion. We do understand there are kind of challenges to the factual findings related to the district court's opinion on that score, and the district court didn't resolve the hand-to-hand transaction findings. So that's why we are asking for a remand there, as opposed to straight affirmance on the reasonable articulable suspicion. But that would be our position on that. If there are no further questions, we'd ask this court to go.
All right, thank you. Ms. Wright, we'll give you 2 minutes for rebuttal.
Thank you. The government says that the court found that Officer Torres saw the bulge from the side and went parallel, and that dooms our argument. But this is not at all inconsistent with him turning, because the officer is.
What should the officer have done, according to your view? He's walking beside the defendant, and the defendant does not turn around, insists on walking. What should the officer have done then?
Well, it's our position that he shouldn't have told him to stop at all, because there was no.
No, let's take it from where the video takes it. The officer's walking beside him, tells the defendant to stop or no, and the defendant keeps walking. What should the officer have done?
Well, he could have said stop at that point, but the officer can do whatever the officer wants, but the question is.
We've been debating this now for 20 minutes. How long did this encounter take?
He stopped within 1 second.
in 1 second.
Excuse me, he was seized within 1 second.
I mean, even if he was the most brilliant expert in the Fourth Amendment, do you think he went through all the calculations and machinations that we're going through in 20 minutes of oral argument by competent counsel?
But the question is, there was nothing for the officer, no decision to be made by the officer. Under Hodari, the officer makes his show of authority, and then it's the defendant's actions. Nothing the officer could have done or not done would have changed whether Mr. Veney submitted. So there is no split-second decision-making by the officer. The split-second decision-making was when he chose to issue a show of authority, which we would say was a mistake, and we understand those calls are difficult for officers, but what we're talking about was afterwards, in this sort of, at this point, it's just an objective question of whether his actions were a submission. And, you know, the government says that no turn can be seen on the body-worn camera, and we would just say that the screenshots on our brief clearly show there was. And that in the context, merely turning around isn't enough, but that's all he was asked to do. And then finally, the government is saying that a Terry stop is, you know, it's all about being free to leave. And what our point is this is an acquisition by control, in the words of Torres v. Madrid. And here Torres controlled the movements of Mr. Veney. And the other language from Mendenhall, besides being not free to leave, is giving someone direction and suggesting that compliance might be compelled. And so if you comply with what they're trying to compel, that also is a seizure. And we also point to the language in Terry that says, was the defendant's liberty restrained, quote, in some way? And here, I just want to finally say that, you know, by moving his body in the way Torres was demanding and engaging with him despite his expressed desire not to engage with him, because beforehand he's looking dead ahead. I mean, that photograph, you can just see he's studiously walking. And he changes his behavior, gauges and turns in response. And in that way, he is allowing Torres to control him, his movements, and he was thereby seized.
Thank you, counsel.
Thank you.
We'll take the matter under advisement.
Case number 21-1120 et al. Turlock Irrigation District and Modesto Irrigation District petitioners versus Federal Energy Regulatory Commission. Mr. Zetlin for the petitioners, Mr. Fish for the respondent, Mr. Katz for the intervener.
Morning, counsel.
Thank you, Your Honor. Misha Zetlin for the petitioners. 363 days after we submitted our certification request, full of many hundreds of pages of water quality information, the California board here purported to deny our certification request with a 2-page pro forma letter, and then told us to resubmit our application again if we wanted to keep an active file. We, of course, complied. 364 days later, same pro forma 2-page letter. Now, there's no doubt, I think, in anyone's mind what was going on here is that the board wanted to buy itself more time to draft up its eventually very lengthy certification.
Well, it seems like there is some question about that. You call this pro forma, but there was some reasoning. And the reasoning was that the district had not completed the CEQA process. And without that, state law prevented the board from approving the permit, right? That's what they said, right?
That is what you said, Your Honor, and if I could just take that in 2 parts. First, the decision below did not in any way rest on whether that was a legitimately stated reason. FERC set out a bright line rule that as long as the document is labeled a denial, that's an act under 401, and the 1-year statute does not apply. Now, I will answer your question, which which was pressed by the board in their intervener thing, and we would submit what could only be decided on remand under Chenery. Our position is that the invocation of CEQA cannot possibly evade the one-year rule. CEQA is, of course, a state statute. It requires a multi-year study.
But you're saying they evaded the one-year rule. They didn't. They ruled. They denied.
They invoked a
The rule says that you have to act within a year by either granting or denying, and they denied. So they complied with the statute.
They did nothing more than what the agency did in Allegheny, which is that they labeled something in denial, but it was nothing more than a tolling document.
Well, you can't have it both ways. You just said a minute ago that we can't look at really what the order said because the FERC didn't cite the order. And then now you're saying that we should look at this like Allegheny and look behind the order and like infer some sort of bad faith or shenanigans. I mean, you gotta pick a position here.
Well, let me try to explain this very clearly. Our primary submission is that FERC rested its decision here on a bright line rule that no matter anything else, as long as the state document is labeled labeled a denial, that's the end of the inquiry. Now, I think at footnote 2 on page 33 of the brief, they seem to disclaim that. So under Chenery, this court should vacate FERC's decision and let them take a look and actually make a decision whether this was in fact a sham or whether they were actually seeking more water quality information. But with regard to CEQA in particular, let me address that. This is a state statute, a very unusual one, that requires that as a practical matter requires a multi-year study looking at housing, aesthetics, all this other stuff. California has recognized that multi-year process can't possibly override the one-year rule, which is why since they've changed the statute to allow themselves to issue certifications even without CEQA being completed. And in fact, here we have the smoking gun, which is that they in fact issued their certification without CEQA ever starting. They issued a 100-page document, 45 conditions.
But that's because the state law was changed. They didn't have the authority to do that until the state law was changed. They could have just denied your petition or permit application and been done with it, right? Under state law as it existed in 2018.
Your Honor, the existence of a state law cannot possibly override the one-year rule. Let me give Your Honor a hypothetical.
Well, the one-year rule just requires them to act. Well, and they could act by saying denied.
Well, Your Honor, if I may give a hypothetical.
FERC can't overrule what the state does. That's the whole purpose of the cooperative federalism scheme that we have here, is that the state has its authority and FERC has their authority.
The state is not doing anything illegal here, but there's if a state adopts a state law that does not allow them to act within 1 year, then the consequence is waiver. And let me give Your Honor a hypothetical. I think this illustrates why the reliance on CEQA must be wrong. Let's say California decides to enact the following statute tomorrow. Anytime there's a 4-to-1 certification, we need 18 months to study it and then an 18 months of notice and comment to the public. Whenever that gets to 364 days, we're going to deny without prejudice, and we're going to say that's because this 18-month review and the 18 months of notice and comment hasn't completed. Certainly, that would be an act in some way,
you could bring an action against the state to set aside that. And I just want to follow up on Judge Wilkins' questions. How much of your case rests on the idea that they shed without prejudice?
Nothing at all, Your Honor. The word is not
because if the board had simply said denied, and the reason is we don't have sufficient information under state law yet, you would be in the same position. You could again file once that information was available, correct?
They would have to tell us in some way what information they would want.
What they did.
Your Honor, with respect, they never told us a bit of additional information that they needed. We submitted over 1,000 pages of every environmental study.
When they tell you that we can't approve this because you are your client, the district, is the responsible party to initiate the CEQA process and they haven't, that's not telling you what you need to do?
Our respectful submission is the state of California did not need an additional bit of water quality information. And we have the smoking gun, which is the state of California, in fact, issued the certification without getting $1 more of water quality information. I know Your Honor said the state.
That's because they passed a statute that said that the thing that prevented them from granting your application in the past was no longer going to be a requirement.
Your Honor.
So the smoking gun that you're referring to proves the point.
I very strongly disagree because the statute doesn't refer to the board. It refers to the state of California. The state of California, whether it's acting through an organic statute or through its bureaucrats, had decided and showed the world beyond a reasonable doubt in the strongest smoking gun possible that they did not need $1 more of water quality information from us at all. This entire CEQA ruse was in fact a ruse, which is why they kept doing it at.
Why didn't your client just go through the CEQA process?
We provided them with every bit of information that they could possibly need. CEQA process could not have been completed in a year for a project of this complexity and size. They had 1 year to decide, 1 year under the statute and under the federal statute, which overrides their state law for the purposes of these proceedings. They did not finish within 1 year. If we had submitted the CEQA paperwork, they would not have finished within 1 year, and they would have given us the same denial saying CEQA isn't finished. And in fact, they know that that the CEQA is not sufficient justification to override 401, because why did they enact this change of law? They enacted this change of law in response to this court's decision in Hoopa. And the scheme here is far more offensive to the statute than what happened in Hoopa. In Hoopa, at least the agency had to get the agreement of the applicant in order to toll the 1 year limitation. Here, the agency can do it, the state can do it unilaterally. And if your honors, there should be no mistake about it. If your honors rule for my friends in this case, the 1 year statute is meaningless. It is a dead letter. Every state could pass a statute like CEQA or like my hypothetical, saying we need 18 months, we need notice and comment. And Judge Randolph, there would be no way to challenge that statute.
Why not?
Because it wouldn't violate any federal law.
Well, your argument is that it would violate federal law because it precludes the 1 year limitation on granting a certificate.
So it's very important to understand that there's nothing.
If it doesn't violate federal law, as you just said, then why are you complaining to the FERC about that?
It doesn't violate federal law. It just has a consequence under federal law.
It's just in conflict?
No, there's a consequence under federal law with not deciding within 1 year, which is that you waive your certification. There's nothing illegal about waiving your certification, right? In fact, the statute contemplates that. Imagine if, Your Honor, if the enactment.
Do you agree or disagree that the basis for which the denial, the basis on which the denial rested was that the board had not received sufficient information?
That is their claim before this court.
Do you agree that they said that?
I agree that they said that in their briefs here.
Do you think that was plain error on the part of the board?
I do not. FERC here did not rest its decision on that based upon Chenery. It certainly did not.
And you also say that the rule that was stayed for a while, that the Supreme Court just lifted the stay, supports you. Do you realize that that rule says that the board or the authority, the state authority, can reject an application on the basis of insufficient information?
Yes, Your Honor, but
right, and that's a denial within the 1 year period that qualifies for that.
May I point, Your Honor? Obviously, we don't have enough time to look at it now, but when Your Honor, back to Chambers, look at 40 CFR 121.7 E13. That is in that rule, the one that's back into effect, and it says that when the state board says there's not enough information, it needs to tell the applicant what information it needs. Further, the rule says that you can't require multi-year studies. So it is unambiguous that under that rule, this would not be allowed because it would not be a legitimate denial for lack of information because they never told us what information more they needed. In fact,
Your environmental review, didn't they tell you that? You didn't complete your environmental review?
they wanted us to go through a bureaucratic
Well, that's
process.
I'm telling you what the information was that they didn't have sufficient knowledge of.
No, Your Honor, every bit of information was in our hundreds of pages submission. They wanted an additional study. CEQA deals with aesthetics, transportation, cultural rights, things of that sort. This is a multi-year.
Then why didn't you challenge their denial in state court?
The reason, it's very important, the reason for that is that challenge would have failed at the blocks because their state law authorized to do this. And if I could get back to that hypothetical, because I really do think it's devastating. If a state enacted a statute like that said, we need 18 months to study this under our state, and we got to fill out a bunch of forms, and then we get 18 months of notice and comment, there would be no federal claim you could bring against that. That wouldn't violate federal law. It would just be a waiver. And in state law, how would you challenge that? It's a state statute. What state law does that challenge? We respectfully submit that CEQA is exactly the same thing. It creates or it was before the latest statutory enactment, it creates a multi-year process that for any sizable project would never be finished in a year. And if your honors bless the CEQA excuse, then it necessarily follows that you're blessing the hypothetical excuse that I put out. And then 401's one-year rule is absolutely a dead letter. And I had a lot of really intelligent briefs submitted on the other side case, excellent attorneys. Not a single word in those briefs explains why ruling for FERC here would not create a loophole that would render 401 and this one-year rule and this coercion hoop a functional dead letter whenever a state wanted to avoid it. And there's no answer that they have to that critique. Thank you, Your Honors.
Morning, Your Honors. May it please the court, Jared Fish for the commission. The petitioner's argument here is entirely circular, and this gets to your line of questions, Judge Wilkins. They assume that there was no denial here because they say the state courts or the state's reasons for the denial somehow pull the one-year deadline under the statute. But how do we know that there was a denial here? And it's undisputed that the denial letters were issued within the one-year time frame. We know by looking to the text of Section 401. Section 401 says that a waiver of a state's power to grant or deny certification occurs if it fails or refuses to act. We know that a denial, in the next two sentences later in Section 401, means that no federal license can issue. That is contraposed to waiver. The prior sentence says if the state fails or refuses to act, that results in waiver. The federal licensing can continue. If there's a denial, there can be no federal licensing. So the question really is whether the denial here is legitimate. And this gets to your question, Judge Randolph. Section 401 does not empower the commission to answer the why of the denial or to analyze the why of denial. It requires us to look at the when within 1 year and the what, whether the state granted or denied. Whether the denial is legitimate or not, which necessarily includes the questions of whether the denial is based on relevant state law. That's a question, state law to be decided in state court, as this court has repeatedly reinforced in City of Tacoma, in Alcoa, in the Keating decisions. And certainly,
just a point of interest, not necessarily involved in this case, but I was curious if the state does waive its authority to grant a certificate, who determines whether the water quality discharges from the dam or meet the water quality standards?
Well, if the state waives their power to ensure water quality standards, then Congress has allowed the federal license to proceed, and maybe those water standards won't be guaranteed. FERC does conduct a NEPA analysis, so we do conduct our own environmental review.
You did that anyway, right?
We did that anyway, and by the way, we only issued the final determination in July 2020, which was after their second certification request was denied. So as a factual matter, their whole argument that the CEQA analysis held up the federal, or the denials held up the federal licensing is just wrong.
What work is the 1 year deadline doing, if you're correct in this case?
The 1 year deadline imposes an important function because it requires the state to either grant or deny a request. And reasonably,
that's circular. I mean, you said their argument is circular, but I'm asking what's the point of a 1 year deadline requiring a grant or denial?
Because, Your Honor,
if they can just do what they did here.
Well, because that grant or denial could be challenged. And, you know, California, we looked at California state law to determine whether that denial can be challenged in state court. And here, sections 3867A1 of Chapter 20.
Could the same thing be said about the scheme in Hoopa Valley?
No, it can't, Your Honor. And this is a key distinction in the effect of withdrawal and resubmittal versus denial without prejudice. With a withdrawal and resubmittal scheme, there's nothing to challenge. There is no state action. And, you know, petitioners, nobody that I'm aware of, suggests that there is some recourse.
Well, more than that, in the Hoopa type case, which is what you're talking about, right?
Yes.
Both the applicant and the permitting authority of the state have reached an agreement. So they're not going to sue, the applicant is not going to sue the permitting authority because they've already reached a settlement agreement, which is what went on there. That's not this case. This case, the applicant had every right to bring a suit against the state.
Absolutely, Your Honor. And they didn't. They could, you know, they back away from any argument in their rehearing request that California law didn't provide them some recourse through state courts. They abandoned that argument, and for good reason. We have, you know, there's state statutes that reasonably provide them with the right. And even if there's a question, this would be a particularly poor vehicle to try to federalize that inquiry because they didn't even try to seek recourse in state court from the denials.
I know, but your response to my question was very reliant on the option of recourse in state court. And I still don't see how your scheme, even allowing for recourse in state court, doesn't make the 1 year deadline, as opposing counsel said, a dead letter. Because so they do what they did here, and let's say that they'd gone to state court. The state court, they're not going to fault the commission. The commission didn't do anything. You know, how would they win in state court? What would that opinion even look like?
Well, if the state court found that the denial was truly pro forma, which it was not, but they argued it was, provide no rationale for why the board had denied, the state court would presumably, under an analogous, you know, APA administrative review process, arbitrary capricious standard of review perhaps, would say, you haven't provided a reasoned explanation for your denial. So we're overturning the denial. And by the way, there's plenty of precedent of state courts doing just that. In the Long Lake decision.
What's your response to the 18-month hypothetical?
I'm sorry,
what's your response to opposing counsel's hypothetical about a state that passes a statute that requires an 18-month process?
My response to that, Your Honor, is what Congress giveth, it can taketh away. Congress here created the power for states to grant or deny water quality certifications. And when Congress granted that power, Congress could have decided to condition those grants or denials. It could have said, you waive your right to certify unless your denial is based on a substantive, on the merits determination.
Right. We can assume they didn't do that. But so I think your answer is that the hypothetical opposing counsel gave would be perfectly lawful.
Well, it's probable that it would be under Section 401. Again, you know, look at this court's precedent. City of Tacoma, it said our job is to.
And then, so let's say that there's a hypothetical world exists. The commission 2 days before the 1 year deadline denies it without prejudice, but doesn't have to say without prejudice, just denies it, says we haven't completed this process that we're required to complete by state law. And then they seek recourse in state court. The state court is going to say, well, the commission didn't do anything wrong. The commission's just following state law here. So your recourse in state court is out the window. It's not helpful to them at all.
So I have two answers, Your Honor.
And the 1 year deadline's dead letter.
1 year deadline is a function of what Congress set forth. Congress did not provide legitimate versus illegitimate rationales for denial. It just said you must deny. It's the when and the what, not the why. Congress.
But Hoopa says that we can't allow a loophole that's that gaping.
Well, what Hoopa Valley said, Your Honor, and I respectfully disagree, it was based on the failure to act, to grant or deny certification at all. It said whatever failure or refusal to act means, it certainly encompasses the situation here because the states were, quote, deliberately.
Tell me why this is wrong. Hoopa said the state has to make a decision within a year.
Right.
And the state had concocted a scheme where it got around that deadline and didn't make it. It did not make a decision within a year. Right. And here, same 1 year deadline exists. The state has to make a decision within a year. And the state seems to, in the hypothetical that you say would be lawful, the state has literally passed a statute saying we will not make a decision within a year. You say that's fine.
But Your Honor, I push back on the premise of your question that a state decision must be a conclusive determination whether or not a project complies with water quality standards. Section 401 doesn't say that. There's nothing that says a decision that says we cannot yet determine whether water quality standards are actually met is illegitimate, rather than a decision that says we've concluded, definitively that water quality standards are not or are met. So a decision is just the denial itself.
I mean, you're saying that a non-decision is a decision.
No, I'm saying that, like I said,
we need more time. Let's say this is denied because we need more time. Isn't that a non-decision?
No, not under Section 401, Your Honor, because the decision is the denial itself. All that Section 401 says is the state has to, on a certification request, here the state acted by denying. And under the plain terms of Section 401, a denial means federal licensing doesn't proceed. Now, whether that denial is based on a legitimate state ground, this court, again, Alcoa Heating City of Tacoma has repeatedly said the legitimacy, the why of the denial to be challenged in state court. I would say, Your Honor, that while not at issue here, because as you pointed out, Judge Randolph, there was an explanation for the denial, there could be an outer bound. There could be a possibility or possible scenario where the why might be a federal question. This gets.
And did FERC say that below, or is that a generate thing?
Well, we did say in paragraph 33 of our initial order that this is not a totally defined area of the law yet, and so it could be possible that a scheme of a different state scheme might, trigger waiver. But all we're saying is, we come to the court, we await your decisions, and we'll follow whatever.
There's another problem which you haven't mentioned. I don't know whether it's pure speculation or not, but it would seem to me that an applicant could game this system in following what the petitioners are proposing here. And by that, I mean they could file with the state board knowing full well that the information was not available. No, there wasn't sufficient information just to get the ball rolling, and then wind up with having the state waive everything because it's not a final decision when the state says, we don't have enough information, we're going to have to deny this.
Exactly, Your Honor. And we make that point in our brief, and that was the situation in the New York 1 and New York 2 cases, right, where the state didn't have sufficient information, and it said we can't render a decision within 1 year of receipt of request. That is a federal requirement. The 1 year clock starts at receipt of the request, not when the state has complete information.
I'm wondering how effective this 1 year thing is. I mean, it only runs from the date of the application. Is there any kind of time limit on when the application has to be made?
Yes, it has to be filed within 60 days of FERC's issuance of an draft environmental impact statement. Okay. But I'd just like to, on that point, push back against the notion that there's some, meaningful distinction between lack of information and lack of analysis. Analysis is information. The whole reason that state goes through the CEQA environmental review process or FERC goes through the NEPA federal environmental review process is to take that raw data and draw conclusions from it. I mean, raw data is just raw data. The analysis is what matters. And not even petitioners dispute that the CEQA analysis is tied to making determination on water quality standards. So just to get back to your point, Judge Walker, I think there could be an outer bound where a state issues a denial letter with no explanation, and because as the Supreme Court has stated in SD Warren at 386, and the Second Circuit said in the American Rivers case at 107, the state certification power is circumscribed by, has to have a nexus to maintaining water quality. Then in that case, perhaps there could be a, federal question on whether there is any nexus to maintaining water quality, or if the state was just denying certification for economic reasons, or because maybe it wanted power from a solar facility rather than a hydroelectric dam. But we are far afield from that situation here, where petitioners make no argument that the CEQA analysis has no bearing on maintaining water quality at all.
If I read FERC's decision below to be far more categorical than what you just said, I read it in JA 2027 to say FERC was, quote, FERC is, quote, reluctant to interpret 404's text to include denials without prejudice. Categorically reluctant. Then should we remand and allow FERC the opportunity to make the kind of individualized finding that you're arguing here, but that they didn't make?
No, not at all, Your Honor. All I'm proposing is there could hypothetically be.
Why not?
I'm sorry?
Why not? Why shouldn't we? If you're making an argument here that FERC didn't make below, why shouldn't we remand for FERC to make it below?
I'm perfectly happy for the court to rest on the rationale provided in our orders, and in fact, that's mandated by SEC versus Chenery. I'm just responding to your question, Your Honor, to speculate that could there possibly be a scenario where a denial without prejudice, within 1 year would actually constitute waiver. My short answer is I don't know. I can speculate, and that's what I'm doing here. But this is a pretty categorical rule, and the court doesn't need to look far beyond its own precedent to determine that. Again, City of Tacoma explains that our role is to await and then defer to a determination. That's different from two other scenarios, if I might briefly posit them. There are two other federal questions in Section 401 besides the 1 year waiver time limit. One is whether the state has issued public notice of the certification request. That's the City of Tacoma case. This court vacated and remanded for FERC to determine whether the state had actually issued public notice. The second is whether a state under Section 401A3 has properly revoked a previously granted certification under for the reasons that are expressly provided in Section 401A3. That's the Keating case, where the court explained that FERC can't just shirk its responsibility to make that determination whether the state properly revoked. But why is that different from here? It's different because those requirements are spelled out in Section 401 itself. Section 401, by contrast, says nothing about us looking at the rationales for the denial that the state gives. The proper locale for challenging the rationale here was in state court, which the districts did not even attempt to do.
Let me ask one more hypothetical. Imagine that instead of the 18th month hypothetical, it's 100 years. And California passes a statute, says we require an environmental impact assessment that will take us 100 years to do. And because of this 1 year 401 deadline, we're instructing the commission every 363 days to deny and require the petitioner to refile for 100 years. Well, you think that state statute, that scheme would not be would not contradict? You think that scheme would be legal?
I don't know that it would contradict Section 401 because Section 401 doesn't go. But, however, I certainly think that would probably prompt Congress to amend its law to say, look,
I'm sure Congress will be right on that with FERC at the top of their agenda.
Well, regardless of the practicalities, I mean, this is a power, the certification power that Congress has given, and it can condition it or it can take it away. And here, Congress decided to leave it at, if you deny certification, then FERC's responsibility is to consider whether it was within.
But if the argument, well, Congress can fix it, if that argument would fly, then Hoopa Valley would have come out differently.
No, Your Honor, it wouldn't, because there was a failure to act, and act means to grant or deny something. There was no grant or denial there, so there was waiver. If I might make one final point on Allegheny, Your Honor. Allegheny is nothing like this case. There, in a case that concerned the Natural Gas Act's judicial review provision, the court rejected FERC's practice that overrode an express statutory right to seek judicial review 30 days after a rehearing request was filed. We issued orders that said, no, you don't actually get to exercise that right to judicial review. Here, what happened was exactly what the statute prescribes. The state denied certification. It did so within 1 year. And the statute says, in the case of a denial, no federal license shall issue. That's exactly what happened.
I have one further question, if you indulge me. I brought up to the petitioner's counsel the current rule that the Supreme Court had before us, and we have a number of letters back and forth. Here's my question. The third application that the districts made was filed on July 20th, 2020, right?
Yes, Your Honor.
This rule went into effect on July 10th, 2020. And there's a provision in the rule that says the certification denial shall not preclude a project proponent from submitting a new certification request. So with respect to their third request, the rule, that wouldn't be retroactive application, would it?
Well, 2 points, Your Honor. First, the third request is not at issue here. All petitioners are telling
I understand that,
right?
But they withdrew it, and that's why it's not at issue. But they could have, but that request would not have been precluded under the rule that was then in effect.
I don't know that that's accurate, Your Honor, because while the rule was issued in July 2020, it did not take effect until September.
Oh, okay.
So,
okay.
But on that point, petitioner cited section 121.7E3 of the new rule that says, and actually they make a concession in that statement, because they concede that a legitimate denial may be one that's based on insufficient information, which includes an lack of environmental analysis that they didn't even commence. They concede that that could be a legitimate basis. The fact that that new rule requires, an evidentiary showing, that's a facet of the rule. That's not a facet of the statute. So what they're conceding is the statute actually distinguishes between tolling orders and evasion of the 1 year deadline on one hand, and denials that are based on a lack of information on the other. The fact that there was, maybe this would be a harder case if the new rule applied to it because of that lack of evidentiary burden tying the denial to precise water quality standards, that's irrelevant and actually makes our point.
Got it. Thank you.
Thank you, Your Honors.
Thank you. Now hear from Mr. Katz on behalf of intervener.
May it please the court, excuse me, Eric Katz for the California State Water Resources Control Board. This is a straightforward statutory interpretation case. In Section 401, Congress granted the states powerful authority to protect their water quality from the impacts of federally licensed projects. States can act by certifying that the projects will comply with state law, or they can deny certification, which blocks the federal agency from issuing the federal permit or license at all. And they only waive their authority either by an affirmative statement or if they fail or refuse to act on a request within 1 year. And as this court held in Alcoa, those terms are largely unqualified, and the plain language therefore has to apply. And as FERC found, the state board acted by denying each request within 1 year. And as FERC acknowledged, the why isn't relevant because to FERC's determination as to whether there was a timely denial, because certainly that's a question of state law, and that is if the districts were dissatisfied with the board's denial, they had every opportunity to seek review in state court, but they did not. Not finding any home within the text, the districts rely on HOOPA, and as the discussion here has already illustrated, the HOOPA case is entirely different, entirely distinguishable from the facts of this case. In HOOPA, of course, there was expressly a commitment for the state to not make a decision. And there was an agreement with the applicants in that case to try to devise a mechanism for the states to not act for years and years and years, but still preserve their authority. And this court found in HOOPA that the mechanism did not relieve the state board of a duty to act, and so found waiver. And here, of course, there was no such thing. The state board acted timely each and every time. I see my time is running, but very briefly, responding to some of the points the district made, they characterized CEQA as unusual, and it is almost the same as NEPA. It has some distinguishing factors, but not very different. They describe the denial as a loophole. It is not a loophole for the state board to exercise the authority that Congress granted it to deny.
What if you had done everything that was done in HOOPA, except instead of having an explicit agreement that the petitioner would withdraw and reapply, you had an explicit agreement that said the board will continue these denials until it feels like it's had enough time to make a decision? Would that change the analysis?
It wouldn't, because in that case, any interested party could challenge the state board's denial in state court. It wouldn't have to just be the applicant. It could have, as in the HOOPA case, it was a third party who was interested in the outcome, but not the applicant or the state. And if the state had denied for illegitimate reasons, any party could sue the state board in state court, and the state would have to defend its decision to deny on the merits as to whether it was arbitrary and capricious or not supported by substantial evidence. So there would be direct judicial review available in that circumstance.
Even if the denial was without prejudice?
Absolutely. The with or without prejudice is really a red herring, because even if whether the state terms the denial with prejudice or without prejudice, nothing precludes the applicant from resubmitting an application and restarting the state's one-year clock to act.
I ask you, Mr. Katz, if I can interrupt you. I want to ask you about that because counsel for FERC told us that you have to file an application within 60 days after FERC certifies its environmental impact statement. How does that work if the applicant files the request within 60 days and it's denied? Then how can the applicant file another request because the 60 days is already run?
I think that there's a little tweak on the timing that when FERC is ready to begin its NEPA process, it issues an order or a document called Ready for Environmental Analysis, which signals it's starting its NEPA process. The 401 cert application to the state has to be filed within 60 days of that. And so the state, would have a year to act within essentially 14 months of the FERC statement that it's beginning its environmental analysis. But in terms of the CEQA timing, the process for the renewal of or reissuance or new licenses for existing facilities starts under FERC's regs, and it's either 4 or 5 years prior to the expiration of their current license. So there are the dam operator and the districts in this case began working on this relicense renewal 4 to 5 years at least before they submitted their certification request to the state. And so to the extent the districts are complaining about the time that it takes to comply with CEQA, there's certainly time for them to begin earlier than, from right when they request for certification.
But I don't think that answers Judge Randolph's question.
Confuses me.
I'll let him say for whether it answers his question, but it didn't seem to answer it to me.
I may not have been.
If the state denies, let's suppose here the state had denied the district's, I guess, request for a permit. How can they and FERC can't move forward with their process until there's a granting by the state? So is the FERC application told or something, or how can the applicant resume the FERC process after getting a denial from the state?
I apologize for not tracking it the first time, but what 401 prevents is FERC issuing a final license until the applicant receives a certification. So if the state denies a request, whether it's with or without prejudice, or an application with or without prejudice, it doesn't necessarily halt FERC continuing with its environmental review, coordinating with the federal fishery agencies. It just would be a hard stop from FERC getting to the end of that process and issuing the new 40-year license to the districts until a certification has been obtained from the state. And so it may be that FERC will have to do the calculus as to whether it wants to continue doing the work given the denial. But I guess I'm not familiar with that, fact pattern in reality to have a grounded response.
Any other questions? All right, thank you, counsel. Counsel for the petitioner, not sure how much time counsel had left. All right, we'll give you 2 minutes, counsel.
Thank you, Your Honor. This wolf comes the wolf. You heard my friend's answer to the 100-year hypothetical. If this court blesses FERC's decision below, there will be nothing stopping states from enacting statutes that stop the permitting process forever. There would be no state law challenges that would be possible for that kind of thing, because that would be a state statute. What's challenge you're going to bring in state court over that 100-year statute? There would be no possible challenge in federal court. It wouldn't violate any federal statute. The only possible consequence would be the 1-year waiver, which FERC in its decision below is telling you it can't find. It can't even look behind the reasoning. So the stakes could not be higher here. If this court affirms FERC's reasoning, which is the only thing that it could do under Chenery, states would have an absolute veto authority to ignore the 1-year rule for 1 year, 2 years, 100 years. And there would be no recourse to state court. There would be no recourse to federal court. The only recourse would be to a very divided Congress. That's clearly not what the statute requires, certainly contrary to the letter and at least the spirit of what this court said in Hoopa. Just briefly answer a couple of the other questions. There's no room for abuse here for the applicants. As the regime laid out in the currently applicable 401 rule articulates, if the state says we need this bit of water quality information, that is not this kind of loophole. And then finally, Your Honor's question about what FERC consider. FERC, as a matter of policy, always considers the waived certifications. If this court finds FERC,
I didn't catch that.
FERC always, as a matter of policy, considers the waived certifications in issuing its final license.
Oh, waive.
Yes, the waive.
WAIV, okay.
That's
Yeah,
right.
got it.
That's right, Your Honor. It always considers those. So it surely didn't HOOPA. And in this circumstance, if this court rules for us, then surely FERC would consider at least some of those 100-page certifications that the board issued more than 2 years after we filed our request.
All right, thank you, counsel. We'll take the matter under submission.